Gentlemen and ladies, how are you today? Here we have a very short topic to quickly deal with. A client of ours wanted to, technically speaking, rent a duplex, a semi-detached duplex here in Lekki, in the sum of 120 million naira. But the point is that the property was actually offered to this couple for a purchase. They wanted to buy the property at the rate of 120 million naira. They have negotiated and everything has been concluded. But you know what? The wife of this very man was privileged to see one of our videos we posted on this platform where we talked about the danger of buying a property with a deed of sublease as a title document that has a clause of less 1 day. She saw that video. That video is actually here on this platform. If you scroll through, you'll be able to go through all the videos we have here. You will see one of the videos where we talk about the danger of buying a property with a title document of a sublease. That when you buy property with a title document of a sublease, you're actually a tenant, technically speaking, on that property. That property does not belong to you. Especially the deed of sublease has a phrase or has a clause of less 1 day. Okay, so when you listen to the video, you'll be able to get the fuller gist of what we talked about in that video. So the wife of this man was privileged to see that very video. And she told the husband that she needed a forensic due diligence to be done. But the husband said no, because the husband, as a matter of fact, is a lawyer. Okay, the husband is a lawyer, but was in, it's a corporate lawyers. Corporate lawyers, they are lawyers, who basically into company, they deal with the company matters and all that. Okay, it's a corporate lawyer, it's not a property lawyer. So the husband said, no, I have already gone to the land registry. This thing actually happens in Lagos. They have already gone to the land registry to, to conduct a search on the deed of assignment, a registered deed of assignment given to him. And there's no encumbrance on it. So there was no need to do a forensic due diligence. But the wife said, I have seen a video where one young man, called Barrister Sam Jack, spoke about the need to go beyond just the normal search at the land registry. That they should dig deeper. So they contacted us. We said, no problem. It's one of the things we do. We are actually helping the people to ensure that they don't run into troubled water. So we went into investigation because the property is actually somewhere around, should I go deeper to mention names? By the way, the property is around the Ikate axis of Lagos, immediately after Lekki Phase 1, you get to Ikate. So during our investigation, we got on the document, the deed of the deed of assignment. It's a deed of assignment. The person wanted to sell the property to this couple. It's a deed of assignment he has. So since it's a deed of assignment, the husband was arguing with the wife that it's a deed of assignment, it's not a deed of sublease. So there is no need of doing further investigation on it because it's a deed of assignment. And the absolute title of the former owner of that property was assigned to this current person who wants to sell to them. So there's no cause for alarm. But the wife insisted that a forensic due diligence should be done. And they consulted us. So we're back on this forensic due diligence. Do you know? Information we got was to the effect that even the person who wants to sell to them never has such information regarding this very property. Do you know the information we got? We discovered that it's a CFO that covers an expanse of land of 113 point something hectares of land, 113 point something hectares of land. That CFO was actually given to a particular family. And I don't, as I said, I don't want to mention this, So that family assigned the entire right they have over that CFO through a vehicle of power of attorney to a particular real estate developer Okay? And that real estate developer took over the whole 113 point something hectares of land. And this real estate developer entered into, it was during our investigations, we were digging and digging and digging, that we kept getting all these pieces of information. Then the real estate developer entered into dredging agreement with a dredging company to help them dredge the land. And there was an agreement to the effect that they will be given 7 plus out of this 113 something hectares of land for the services that dredging company will be ready to this real estate company for the purpose of payment, a form of a payment for that service of dredging that you want to render to the company. I said the real estate company, the family that has the CFO issued to them assigned their entire interest to this real estate company. Absolute assignment of their interest in that CFO. So the whole 99 years, CFO has a lifespan of 99 years. So they transferred the whole 99 years to this real estate company. So when this real estate company entered an agreement with this dredging company, with the promise that when they had them dredge the land, they will give the 7 plus out of the land, that job was actually done. But meanwhile, the owner of this dredging company had a transaction with NPA, Superannuation Fund. Sorry, I just mentioned that name, but anyway, it's our company. Nigeria Port Authority is our company. So it's a Nigerian company, so it belongs to all of us. I can mention that name. So the owner of that dredging company entered into an agreement with Nigeria Port Authority Superannuation Fund. And unfortunately, this dredging company could not pay NPA. So the dredging company then told NPA that they have 7 plus of land to be given to them by that real estate company for a service they render to the company. That NPA should come and take the 7 plus in place of the money they owe them, in place of the money this dredging company owed them. So NPA said, no problem. So NPA's Superannuation Fund came and took over this 7 plus of land. Then a deed of sublease was prepared between this real estate company and NPA Superannuation Fund. Follow me? Forensic due diligence is a very technical, it's a high class of investigation when you're investigating title to property. It's very deep, very, very deep. Yeah? So a deed of sublease was prepared between the real estate company and NPA Superannuation Fund. In that deed of sublease, because I will be reading, there's excerpt from the report we just sent to the class. I have actually gotten their permission, to read a part of that report, So, but for you to know that, by God, we did that report so that it do not look as if we are, taking other people's work. I don't know if you can get it. That is, can you get it? That is our signature there. Then you can see the name. I just pray that you'll be able to see the name. Can you see the name? Oh, I think it's turned upside down. You can see the name. King Sanjay II Akure Francis Chambers. Just to rule out the issue of piracy, I decided to do this not really for any other purpose. You have to be sure there's actually a report. You can equally see, SAQ, because the video is on the reverse side, so it's turned upside down. But if you look at it very well, if you read it the other way, SAQ by Sam Jack. SAQ. SAQ means site acquisition. When we are working for Airtel and Etisalat, that is the name used, so we are still using that name. So you can still see there SAQ, by Sam Jack. So I just want to draw your attention to that, to be very sure that we rule out the issue of using other people's. So that is our signature there. Maybe you'll be able to see the name. If you can see the name here underneath, you'll be able to see the name. I just want to rule out that maybe, come on, is it clearer now? So you can see there. So it's our report. Meanwhile, I have gotten the client's permission to read a part of the report to you so that you will understand what we're talking about. Then that is. But before I read the report, let me quickly say one or two things. Do you know what? The real estate company entered into an agreement with NPA Superannuation Fund regarding those 7 plots of land. And in the deed of sale list they prepared, there was a clause inserted in that deed of sale list. And the clause is to the effect that, I will just read that clause to you now. It's to the effect that, now, the deed witnessed as follows. 1. The unexpired term of years granted by the certificate of occupancy less 1 day. Did you just get that? The unexpired the unexpired term of years granted by the certificate of occupancy less 1 day. Okay? In the deed of sale list prepared by the real estate developer company to NPA, that phrase was contained in that deed of sale list. But do you know, before we were able to dig to get this document, the owner of the house who want to sell it to our client didn't even know that this was the position, because the family, as I said, gave a deed of assigned the whole 99 years to the real estate company. And the real estate company, while assigning the 7 plots of land to NPA Superannuation, they withheld 1 day out of the residue in that 99 years, assuming as at the time they were assigning the 7 plots to NPA Superannuation, they have already spent 2 years on that land. It means the remaining 98, or rather, 2 away from 99, the remaining 97 years they were assigning to NPA, they removed 1 day. You saw it in that agreement I just read to you, less 1 day. What that one means is this, that before the CFO will expire, the agreement the real estate company enters with NPA Superannuation would have expired the previous day, assuming the 99 years will be expiring tomorrow, okay? Whereas the agreement between the real estate company and NPA would have expired today. And once it expires today, what it means is that the title of this property will reverse to the original owner. That is the real estate company. The title will reverse to them automatically. Now, let's go deeper. As I was saying, the title assigned by the real estate company, by the family to the real estate company is absolute title. They did a deed of sale, they assigned the whole 99 years to that real estate company via a power of attorney. Whereas, when the real estate company wanted to sell, as it were, it's still a form of selling, 7 plots of the land to NPA, they withheld 1 day. They prepared a deed of sale list. Then, NPA Superannuation went ahead to build several units of duplexes on these 7 plots of land. We are tracing the root of title. That's what we call root of title. That's what we are tracing now. Built several duplexes on the 7 plots of land. In the course of time, Oceanic Insurance Company acquired the property from NPA. The NPA prepared a deed of assignment. You see, the agreement between the real estate company and NPA superannuation, as I stated, was a deed of sublease. And there's a clause that withheld 1 day in that deed of sublease. Whereas when NPA wanted to sell this whole property to Oceanic Company, that later metamorphosed into, or that later changed its name to Old Mutual Insurance Company, it was a deed of assignment, which means NPA Superannuation Fund assigned the entire right they have over that property to Old Mutual Insurance Company. And Old Mutual Insurance Company, that the former Oceanic Insurance Company, equally assigned their entire interest in that particular building they wanted to sell to our client to the person who wanted to sell the property to our client. So you discover that from NPA Superannuation, the agreement between NPA Superannuation and Oceanic Insurance Company, that later changed its name to Old Mutual Insurance Company, it was a deed of assignment. And the agreement between Old Mutual Insurance Company and Mr. XYZ was equally a deed of assignment. Then between XYZ and the person who wants to sell to our client now is equally a deed of assignment. So this was exactly what the husband of this very woman saw and said, it is a deed of assignment that they get to us. So there was no need of doing further investigation. I have investigated in our registry the external branch of the deed of assignment, and the deed of assignment given to us by the person who wants to sell this property now, the document given to us, it's a deed of assignment. Even the one between him and the previous person is a deed of assignment. So there was no need. But it was in the process of digging deeper and deeper, because what we did was actually to get the document between Mr. XYZ, who wanted to sell to our client. We got the document, which is a deed of assignment. So we traced from there, we were able to get the deed of assignment between that person and Old Mutual Insurance Company by going to the company's old office. In fact, they are no longer using the office. They are, we went to the office. When we got to the office, we were able to dig into their archive and then saw the agreement between NPA Superannuation Fund and Oceanic Insurance Company. When we got that, we discovered that it was equally a deed of assignment. So we dug further and then discovered a title document between the real estate company and NPA Superannuation Fund, and discovered that it was a deed of sublease. And in that deed of sublease, there is a clause that withheld 1 day. So which means in the chase of transactions, which means in the root of title of that very duplex, there was a time when a deed of sublease was the agreement between one person and the other. So you see, the original owner of the CFO, the family, assigned their entire interest to that real estate company. But the real estate company was very smart. They didn't assign the entire interest to NPA Superannuation. Rather, they withheld 1 day. But NPA Superannuation transferred their entire interest to Oceanic Insurance Company, that later changed to Old Mutual Insurance Company. Their Old Mutual Insurance Company transferred their entire interest to the person who sold the land to the person who wanted to sell to us now. So in the case of ownership, you discover that there were deed of assignment, deed of assignment, deed of assignment. So if not because we dug further, we wouldn't have discovered that in the chase of transactions, in the cost of ownership of this property, in the root of title of this property, there was a tender, a deed of sublease was prepared that withheld 1 day in the chase of ownership. What that means is that should our client proceed to buy this property, then a day is coming when the real estate company who withheld a day out of that CFO, a day is coming that they will serve a quick notice on our client saying that your rent has expired. Because what was actually created is a long lease. That is how our client almost ended up renting a property for 120 million naira in the guise of buying the property. To our client, the intention was actually to buy the property. The person was selling to them. The intention was to sell to them absolutely. Actually, the person who sold to that person is equally absolute say they sold to him. But even the person who wanted to sell to our client did not know that in the course of ownership of this very property in the past, that there was a time a deed of sublease was prepared that we had one day. Which means a time is coming in life when the ownership of that property will reverse to the real estate company. And that will result in serving of eviction notice by virtue of a fruition of time, saying that their lease, the leasehold had expired. So, in summary, that is how our client almost ended up by renting the property with 120 million naira in the guise that they wanted to buy the property. So, let me give you the final report we sent today. So, the final report we just sent to the client, let me read it here so that you will see it. So, in our, it's captioned a legal opinion. I will quickly read to you. We have carefully and meticulously analyzed the foregoing root or title of Mr. XYZ and found as a fact that he derived an absolute title from the person who sold to him. That is, from Old Mutual Insurance Company, which equally derived his own absolute title. When I say absolute title, I mean the entire right that the previous person has, they transferred to him. So it was a deed of assignment, not a deed of solid. That's what I mean by the absolute title. Who equally owes absolute title transferred from NPA Superannuation Fund. However, NPA Superannuation Fund did not derive an absolute title from that real estate company. Did you get the gist? NPA Superannuation Fund did not derive an absolute title from the real estate company. But the real estate company, however, again, the real estate company derived an absolute title from the family that originally owed the CFO. Okay, you follow me? Follow me, we are going there. When you read closely, we are talking to the client now, here is a report. When you read closely the deed of assignment between the real estate company and NPA Superannuation Fund that is attached to this report, you will observe under the heading, now, the deed witnessed as follows. The unexpired term of years granted by the certificate of occupancy less 1 day and that. You get it? In the deed of sole prepared by the real estate company to NPA Superannuation, that clause was inserted in it. The unexpired residue granted under the CFO less 1 day. Follow me as I read the report. You will equally observe under the same heading in number 4.1 quotational, at the expiration of the term hereby granted to, that is exactly what the real estate company equally inserted in the deed of solid. That is, quotation open. At the expiration of the term hereby granted to peaceably surrender the demised premises to the sublessor. Can you imagine such dangerous stuff? Can you imagine that? That is what the real estate company inserted in the deed of solace. That at the expiration of the term hereby granted, they should peaceably surrender the demised premises to the sublessor, that is to the real estate company. What that means is that they should move out of the property. And if they don't move out, they will go to court to recover possession because it's a lease granted. It's just the same way if you don't have money, you rent you rent a house for one month, or you rent it for 6 months, or you rent it for 1 year. But because these people have money, they rented the house for about 70 years. It's true that they will not be alive when this issue will come up. It's true that the real estate company itself will not be alive, or the owners of the company will not be alive. But the successor of the real estate company and the children of our client would have been the one to have this headlong collision when that time comes. You understand? I'm still reading. Just hold on, follow me. The question is, what is the legal implication or the meaning of the above quoted clauses in any deed or sublease? You follow me? The clauses simply mean that the clauses simply mean that the sublease is that the sublessee, that is our client now. Or let's go to that point. You know, the agreement between the real estate company and NPA Superannuation Fund. We say it's a deed of sublease that we had one day, and we equally a clause saying that at the expiration of this sublease, they should surrender that property back to the real estate company. So we are now asking, what is the legal implication of that very phrase or that very clause or of the clauses in the deed of sublease between the real estate company and NPA Superannuation Fund? We are looking at the legal implication of it now. Knowledge is power, my dear brother. You know, the clauses simply mean that the sublessee, that is NPA Superannuation Fund, that is the sublessee, okay? The clauses simply mean that the sublessee is a tenant of the sublessor. The sublessor is the real estate company, okay? And that at the end of the long lease that is granted, the sublessee shall surrender the title of the property to the sublessor. That NPA Superannuation will surrender the title of the property to the real estate company. But the fact that they have now sold the property to Oceanic Insurance Company, who that later changed to Old Mutual Insurance Company, then that one now sold to another one, that one now sold to another one. What it means is that because they derive their title from that CFO, it means when the whole time expires, then the real estate company will activate this very clause in the agreement, in the root of title of all other persons who derive title from this CFO. Because when that time comes, it's just like somebody who is on the, because our client would have actually been maybe the fifth owner of that property. So it's just like you are on top of a four-story building. If the ground floor is crumbled, what happened? You that is on top of the building will crash land. You got the gist. Oh dear. So we are still going. We are still reading the report. You know, as I said, we have our class permission to read this report to educate Nigerians, so that when we keep talking about this, digging deeper into the root of title that can only be done through forensic due diligence. It's not just to go to the land registry to conduct a search and come back, you say all is well, you go ahead and buy property, so that you will know exactly what we're talking about. So this is a practical example of what we have been talking about. It has just happened. And by virtue of this, one of the video we posted, that this has just happened. The wife insisted and told the husband, although you are a lawyer, but you are not a property lawyer, you are a corporate lawyer, so let lawyers who are experts in this field do their job. And the job we did now is what is revealing all of these things. Even to the extent that the person who wants to sell the property to them is not even aware of this fact. He's not even aware that in the cost, in the chase of transaction of the property that he has, there was a time a deed of sublease that we heard one day was prepared, because he said he had never seen that copy before. He said he had never seen that agreement before. He said he's not even aware. He said he's not even aware. And the person wants to say to our client, that's what he said. I believe him. It's true. He's never aware because he never bothered to do any deeper investigation to that effect. So I still reading the report. Now, who is a sublessor? And who is a sublessee in the deed of sublease between the real estate company and NPA Superannuation Fund? The real estate company is the sublessor, and NPA Superannuation Fund is the sublessee. That means the title that the real estate company transferred to NPA was that of a long lease, and the long lease will expire someday, just like every other long leasehold in tenancy relationship between a tenant and his landlord. When the leasehold expires in future, the title of Superannuation Fund shall reverse to the real estate company. You get what I'm talking about? Shall reverse to the real estate company. What that means is that since in law you cannot give what you don't have, that the mother could not have bed. We say that in Latin mass, the mother could not have bed. What you don't have, you cannot give it. Since, let me go back to the report again now. What that means is that since in law you cannot give what you don't have, that is the mother could not have bed. What FPA Superannuation Fund assigned to Oceanic Insurance company, okay, follow me, assigned to insurance company, is actually a deed of solely, although they call it an assignment, because the root of title say that what was given to FPA Superannuation Company was not an absolute assignment. So even if FPA Superannuation Company assigned the entire right they have over that property to Oceanic Company, it is still subject to that deed of solely that withheld money from that transaction. But it's the root of title that is a key. Because before you see 3, you must have passed through 1, you must have seen 1, 2, before you get to 3, and before you get to 4, before you get to 5. Okay? Because you must trace the root of title from number 1 before you get to higher numbers. So that is where we are. Now, the report is still going. Going by the above legal analysis, it means if you buy this property, you are actually leasing the property for 68 years, 11 months, and 30 days before your long leasehold on the property will expire, and the title will reverse to the original family. That is, rather to the real estate company. Did you get that? Oh boy, this is wonderful. It further means that if God keeps you alive then, or your children will be expected, or rather your children will be expecting an eviction or a quick notice from the real estate company when that time stated in the deed of leasehold, comes. That they will be requesting that you or your children vacate their land. And you will be allowed, however, to renew the deed of sole lease at the value of the land when that time comes. You can imagine that. You may be allowed to review it, but the value of the land, when that time comes, it's going to be the value of the land when that time comes. So what then happens if you, in case you are still alive, or your children don't have the financial means to renew this leasehold when that time comes? What then happens if they don't have the financial means to renew it? Because the value of the land, the renewal will be based on the current value of the land when that time comes. What then happens if they are unable to renew it? They don't have the financial capacity. It means they'll be thrown out. Follow me. We are seeing on the report. We stated, God forbid that you or your children are not financially ready to renew the title of the land. It then means that the real estate company may be asking you to remove the building from their land. That is, if they don't claim from you that the expiration of the long lease, that if they don't claim from you, that is, from you, after the expiration of the long lease, the building, because the law says in Latin Mazin, quick platatu, solo said. quick platatu. What that means is that it means what is affixed to the land belongs or forms part of the land. Or in the other way around, what is affixed to the land belongs to the owner of the land. Quick platatu. So that is the position of the law. Okay? In other words, what is affixed to the land belongs to the owner of the land. You may, however, be able to claim compensation for the building of the land since same was built with the consent of the real estate company. However, in the event that you desire to proceed to consummate the same transaction, so we are advising our client in the event that the client wants to still proceed, in spite of all of this, to buy this property, we are saying we humbly recommend that Old Mutual Insurance Company should assign the property to you directly. That is, after the company has established the fact that there is no some other details. Okay, so let's get to the concluding part of it now. The legal advice. When we do this, we will give the final legal advice. That's the final. You see that the legal advice. That's the final legal advice now. When I say, in view of the series of challenges on the title of the seller, the porous nature of the security in the neighborhood, and especially in view of the nature of type of title that will be transferred to you, which is more or less a long lease of 69 years, we humbly advise that you should source for alternative property. You should source for an alternative property elsewhere, where you will be able to get a title assigned to you absolutely. Because is it not funny? Is it not funny that you labor to buy a property with the hope that your children will come and inherit this property for you tomorrow, only for your children to enter a property after you have gone? You live up to 80, 90, 100 years, you are gone. Your children celebrate your passage, believing that they inherited property from you. Then they will be served a quick notice later in life, saying that this property your father, built or bought, their leasehold over that property has expired. Just think about that. That's exactly what would have happened to this couple. So when we just said this, report to the lady, because it was actually the lady that contacted us, because the husband being a lawyer who has already gone to the land registry by himself to change the coupons on it. But since the husband, rather the wife said that she saw a video on this Facebook page that talks about the legal implication of some of these things, the woman insisted that this due diligence must be done. As a matter of fact, a whole 120 million naira would have been spent on a property to lease that property, believing that they were buying a property. The truth of the matter is, how much did they even pay to help them get this kind of legal job done? How much? You only pay just the standard fee that Nigeria Bar Association has, stated now that in real estate transaction, that's what you should be paying. That's what they pay. They didn't pay more than that. Just the standard fee stated by the Nigeria Port Authority, rather by NBA, Nigeria Bar Association, that lawyers to be charging on real estate transaction. That's all we charge, and that's all they paid. But that money, which is a peanut compared to a whole 120 million naira. Just imagine how you would have spent 120 million naira on a property, believing that you bought that property, not knowing that it was actually a long lease right you have over that property. That the title would have reversed to the former owner. Because if you look at it, the danger in this very transaction, as a matter of fact, is the fact that, let's put it on a scale. The CFO was issued to a particular family. And then the family gave and set their absolute right over that CFO. Absolutely, they did reserve it to this real estate company. Then this real estate company created a sublease, not an assignment. In that video, go through my page, you will see there's a difference between a deed of assignment and a deed of sublease. A deed of assignment means absolute assignment. But a deed of sublease is a leasehold, just no matter as you are a tenant. If you have a property that has a title document saying deed of sublease, you are a tenant, my brother. Irrespective of whether you bought that property 1 billion, it does not matter. You are a tenant. Especially when you read through the clauses in that agreement that says that the person has giving you that, or we are buying the property from, where that person withholds 1 day. And with the second clause I just read in that report, that at the expiration of this lease, or at the expiration of this lease, so the title will reverse to the person who is selling to you. You are a pure tenant, irrespective of how much you pay on that property. Irrespective of the fact that you are going to spend 80 years, 99 years on that property, you are a tenant. A day is coming in a future when your children will be served a quick notice. So as we are saying, the family that the government gave the CFO is number one. Then the family assign absolute title of that CFO to the real estate developer. But when the real estate developer wanted to assign to LPA Superannuation Company, they created, instead of a deed of assignment, they created a deed of sublease withholding 1 day. Which means what LPA Superannuation, the third owner of that CFO now, what they have is not the whole power in that CFO. Their whole power will expire a day before the CFO itself will expire. Whereas when LPA Superannuation wanted to assign this property to Oceanic Insurance Company that later changed its name to Old Mutual Insurance Company, they assigned the entire right. The entire right LPA has it assigned to this Oceanic company. So which means between this one and this one, it was a deed of assignment. But between number one and number two, technically speaking, a deed of assignment. The government assigned, gave the CFO to the family. The family assigned absolute, for example, a deed of assignment to this very real estate company. But real estate company did not assign their absolute title over the property to LPA. But when LPA wanted to sell to Oceanic, they assigned their absolute title. So it's a deed of assignment between LPA and Oceanic Company. And when Oceanic Company wanted to sell to Mr. XYZ, it was equally a deed of assignment, assigning the entire title to XYZ. So when XYZ wanted to sell to our client now, who is the number 6th owner of that property, it was equally a deed of assignment they wanted to assign. But in the course of the change, you see, in the root of title, when you look at it now, this is the root of title. 1, 2, 3, 4, 5, 6. So our client is the 6th person. It means in the change of the root of title, when you are tracing the root of title, when we say root of title, just look at this now as if it was a tree. You trace from the root, you entered. This is the root. This is the stem. This is a branch number 1. This is branch number 2. This is another branch of the tree. And finally, our client is you may call it the leaf, as it were, on top of that tree. So in law, when we are doing forensic due diligence, we have to trace from the root of title. So when we trace from the root of title down to this place, down to our client, we discover that in the case of ownership of this other property, our client being the number 6th person, in the course of the ownership, there was a time that a deed of sublease less 1 day was created here. It means the right of these persons, this person, they are all standing on top of this person. They are dependent on this person. So when that time comes that the title created between this person and this person expires, it means the title of all these people on top of this person will crumble. Everything will fall on top of this very person. Do you get the gist? In essence, what we are saying is this. Oh God. We Nigerians, we are very smart. We just believe that because we have the money, we don't really need to go into investigation, especially when we know that our friend bought property from the same real estate developer now, so there was no problem. In fact, everywhere he built is the same real estate developer that built this 30 units of duplexes. Or is this a real estate developer that owns this 50 plus of land? So every other person have been buying. So if those people are not afraid to buy, so why should I be afraid? But you have discovered, my brother, this same reason is why we see crowd of people in the various courts today. Why are they there? For land matters, for failure to do what they ought to have done. So, in conclusion, when you are hustling for money to buy property, equally hustle for money to pay a real estate or a property lawyer to help you investigate the title. Because to hustle for money to buy property is one thing. But to buy a property that is not problematic, that will not result in litigation, or as I always say, that you will not buy a litigation-infested property, It's another thing. As a matter of fact, that is even the most important thing. But unfortunately, I have seen in practice that people want to invest in property after they have gotten money or they have kept the money to pay for the property. The next money they look for is to pay agents, agency fee, to pay the agents who showed them the property. But the lawyer who will help them investigate the title of the property to be sure that the title is okay, they will not tell the lawyer, you see, I don't have money, please manage this peanut, manage that, manage this, manage that. Isn't that foolishness? That you want to pay millions of naira on property? The person who wants to help you investigate to be sure that this one you want to pay will not be wasted, will not result in litigation tomorrow. You are not telling the person you don't have money to pay his fee. Isn't that foolishness? But whereas agents who didn't really do anything, rather than to just show you property, all they did was to show you the address of the property, they take you to the property for inspection, and that is all. The agent sees that you must pay him 5%. And you say, you see, I don't want to miss this property, you go ahead and pay the agent, the 5%. You go ahead and pay the agent the 5%. But the person who will help you to secure or to help you investigate whether this money you want to invest is on the precarious, whether the investor is a problematic investor, this investor that will put you in trouble tomorrow, you tell the person you don't have money. And if you don't pay your lawyers well to do their job, tell me, how do you expect them to do the job? For example, like this very forensic due diligence I just told you about. The person who even sold this property to the person who wanted to sell to our client, they don't even know about this history of that property. And according to him, he actually, the man who originally owned the land, the fourth person bought the duplex from Oceanic Company. And that fourth person sold the duplex to the fifth person. It's the fifth person that wanted to sell to our client now be the sixth person. So because we had a meeting with the fourth person, we had a meeting with the fifth person, and the two of them claimed that they didn't even know the details of this information. We dug out during or in the course of our forensic due diligence. They didn't know, because at the time they just bought the property just like that. But funny enough, I strongly believe they had the money to pay the agents their 5% agency fee in case it's the island of Lagos, or if it's on the mainland, some other places, it's 10%. They pay the agent their 10% agency fee or 5% agency fee as it were. But when it comes to the lawyer who will help them investigate the title to be sure that the title is okay, to be sure that they will run into troubled water in the course of occupying that property, that they will have peaceful, enjoyment of that property, they will tell the lawyer they don't have money. And that is how you see these days that, unfortunately, a lot of sharp practices are happening in this industry. Because when you pay your service providers very well, there is no reason why they will not do their job as they ought to be done. But when you want to cut corners, and some dubious and dishonest service providers will equally follow you and cut corners, at the end, you land in trouble. But we thank God that people like us will always insist on our fee. If you cannot pay our fee, walk away. You understand? Because we know our onions. We insist that our fee... Yeah, sorry for that break in transmission. So we usually insist that our fee must be paid in full so that we too will be able to deliver on our jobs. Because it is only when we deliver on our jobs that you can refer us. Can you just imagine, if not because of the video that lady saw, and then insisted and told the husband that a forensic due diligence must be done, they would have ended up paying 120 million naira, claiming that they bought a property, not knowing that they were actually renting that property for a period of approximately 69 years. It's true that they will not live to see that day. But what about the children who are celebrating, happy that our parents labor to have this investment of grant? Would the children start cursing you in the grave if it's not discovered at the end of the day that this very property they thought they have, their parents, they inherited from their parents, is actually, it's actually a lease, a long lease that was created on that property? You get what I'm talking about? Knowledge is power. And for you to get that knowledge, get the right people involved in it. Share this video. Let us know your comment. And as I said, the most critical thing, when you are looking for money to buy property, equally look for money to pay your lawyer, equally look for money to pay your agent. So that when you have these three-dimensional funds available before you proceed to buy property, don't say, I don't have the money. And so far I had the money to pay, the purchase price. If you pay the purchase price, what about the title of that property? How can you be so sure? Even if you are buying that property from your brother, from your sister, even from your village, how can you be very sure that all is well with the root or title of that property? Just like this very one. If not because we dug deeper and deeper, this couple would have ended up wasting that 120 million naira to rent a property in the name that they were buying property. God forbid bad. Okay? Share this video with your brothers and sisters. Share it with everyone. Let them learn from it. We need to continue to educate Nigerians so that they will not make mistakes. Because this thing I'm talking about, Nigerians in diaspora, those in Nigeria, whether they are educated or not educated, we just believe all we are interested is to look for money to buy property. We don't care to get professionals involved in the cost of purchase of that property, and as such, we end up in troubled water. In fact, some people will even look for cheap labor. Lawyers who are not seasoned property lawyers. Lawyers, because as I always say, we have different views in this profession. There are people who are very versed, who are very articulate, who are very smart in different fields. For example, a constitutional lawyer, if you election petition, as a matter of fact, do you know, if I may digress a bit, do you know why we recorded so many losses during the election petition tribunal or during the election petition cases? It is because most of the petitioners did not get the services of experts. There are experts we know in this job. They did not engage the services of experts. So, to just engage a lawyer to help you do a particular thing is one thing. But to engage the right person who has the requisite knowledge, who knows his onions in that very branch of the law, you cannot get the result you want. And that is what resulted in a whole lot of cases that a lot of petitions were thrown out. Because many people who are not experts in election petition matters were engaged. And many Nigerians who are not lawyers will say that our judges compromise their integrity. Not at all. Because if you fail to prove your case, can you imagine, for example, if I may quickly say this, a whole election petition matter, you claim that there was this, there was that, there was this, yet you did not bother to call a single polling unit agent to prove your case. The court of law is not a jamboree, it's not a father Christ. It doesn't give to you what you did ask for. It cannot just go out and give to you what, you must, he who has some approve. Okay? So, you see what is happening today. I don't have money, God help me. And because of that, you will not engage experts to help you get things done at the right time. The name remains. Barisa Sam Jack Aika Yakubu, no more no Samudiana Grace Salamis. I remain your guardian angels in or on your journey to the promised land of acquiring your property. We are here giving you these free legal tips to guide you aright so that you don't make mistakes. Just the same, we withdraw that free legal tips on this page. That woman saw it and then insisted that the husband must get the right thing done, and they did the right thing. See the result. Today they are happy that they didn't waste the whole 120 million naira to rent a property in the name that they were buying property. So that is what we are here for, to help Nigerians, so that they don't continue to waste their money. We love you. Share, comment, and follow us so that whenever we come online, whenever we drop videos, you will already be the first to hear, to learn from it. Even if you don't have money to buy property today, continue to listen to these things so that you will now become an informed real estate investor. So that when the time comes for you to buy your own, you will not have any problem. You would have gathered, or you would have garnered, or you would have had enough knowledge about this real estate. And as you continue to follow this page, we know such knowledge would definitely come upon you, even if you are not a lawyer. We love you. Share, comment, and let us know how you feel about this video. Bye for now. Wow.